Hello, everybody. Adam Parks here with another episode of Receivables Roundtable. Today, I'm here with my new friend, Mr. Michael A. Gold, who has recently joined the Pollack Rosen firm down in Miami. How you doing today, Michael?
I'm doing well. Thanks for having me.
Well, I'm really getting the opportunity, I feel like the first look to get to know you here, and I really appreciate you coming on. I know the folks over at Pollack Rosen really well, but this is the first time that you and I have had a chance to catch up. Could you tell myself and the audience a little bit about yourself and how you got to the seat that you're in today?
Sure. I guess, I just started literally with Pollack Rosen yesterday. But to go, literally, but although I'm in and out, but to go backwards a little bit, I'm a Florida boy, born and bred. Ended up going to University of South Florida, graduated with a finance degree, left Florida, never to come back, and got inspired to go to law school. And at the age, 28, I decided to go to law school. I went to a law school down in Miami called St. Thomas University. At the time I started, they weren't even accredited. They were provisionally, but they said I could take the bar, and I'm like, I'm in. Did well. I graduated. I was first in my class the first year. I was booked, and then graduated with high honors. From there, I decided to go to Georgetown and get a Master's of Law degree in Securities and Financial Regulations. So I did that, graduated with honors from there. And I ended up coming back to Florida. I got married while I was at Georgetown, and I had passed the bar in Florida. My ex-wife lived in Florida, or her family lived in Florida. That's where I met her. So we came back to Florida to work. My first job was working for a lawyer named Barry Cohen. And if anybody's been around, and at least in Florida, and Barry Cohen was a very high-profile criminal defense attorney. So I started out doing criminal defense I worked for Barry for about 12 years. Worked on some cases. One case that I always mention is the Sabrina Eisenberg case, which had national publicity. They were on Oprah. There's a CNN special on it, and yada yada. So I spent a lot of time in federal court doing a lot of white-collar criminal defense, a lot of mortgage. Part of the time there was when the mortgage crisis happened, and the government was collecting mortgage. And then I ended up going to work at a firm called Walters Levine, and at the time it was Walters Levine, Kling & Smith, and Thomas, and something like that. About 2015, and I've been there, but about 2000 for a couple of years, 6 or 7 years. But 2015, my boss got connected with, I don't know if I can or can't say, Midland Funding, and they hired us to do work on attorney fee litigation. Based, these collection efforts, and they were having issues with entitlement. And my boss said, you handle it, Michael. Since then, it grew. I did so well sort of defending entitlement and coming up with theories on how to beat, the amount of fees, the reasonableness of the fees. We had cases they were showing where there's a $1,200 credit card debt chart, and the defense bar was getting $24,000 in attorney's fees. So we started really pushing back on that, came up with some theories that have been used by others, and it excuse me. And it got to the point where they said, well, why don't you handle the underlying cases for us? So I started getting cases where the certain defense bar showed up. And I don't know if you know Florida. Florida, is, as everybody tells me, is probably in this industry the most litigious state in the union. There's a lot, and there's a lot of guys, defense attorneys out there attempting to get their fees paid by the debt buyers. So I started litigating the underlying cases and got really successful at that. I haven't lost a trial, knock on wood, and it just grew, and it got to the point where people, I'm sorry about that, where other companies started calling Florida, who do we want to hire? My name came up, and I started, and my practice grew, and I have now 7 or 8, I had 7 or 8 of the large debt buyers who, when certain defense attorneys showed up, I'd get a call either from them or for their the collection agency, and they say, hey, can you handle the case? And I've been doing that. In January this year, I decided it was time for me to move on. I think I had run my course in my firm and I needed something different, more of a challenge. And that's how I ended up at Pollack Rosen. And so now I'm at Pollack Rosen. My job, I hope to continue in Florida to litigate some of these cases still. I mean, I've talked to a few of my former clients who said, when we get new cases, we want to send them to you. And we want you to be a part of our team. So I hopefully will be able to litigate these cases in Florida. But the bigger project, and really why I was brought on at Pollack Rosen, is to help direct and coordinate defense litigation throughout the country. Pollack Rosen currently has a footprint with law firms in about 16 states. And they're looking for somebody with my kind of experience to help the attorney in Ohio or whatever state it may be. Hey, I have this issue. I got this attorney is a real problem, or I got this attorney keeps filing class actions, or I got this attorney who does this. Okay, here's what we need to do. And so I'm hoping to translate what it is I do, what it is I've learned in my 9 years litigating in this field to other states and hopefully bring some order back in the chaos that arises from time to time.
It's a very interesting approach, because when you think about a creditor's rights firm, you don't often think about the litigation defense support, type of role. And it sounds like you're taking on a very kind of a groundbreaking approach to a age-old problem.
Well, that's what excited me about the job. And really, I'd be honest, I had several offers when I left. But this one sort of gave me this opportunity not only to do what it is I enjoy doing and I've been doing and I've been, in my opinion, doing well, but to help spread the word, so to speak. I've, actually in the past, I've had some of the debt buyers, I think Resurgent, I did a 4-part lecture series where they had all their in-house counsel, all their out-house counsel. And, I grew up, my mother was a teacher. I like teaching. I coach my kids in soccer as they grew up. So I do enjoy, hey, let's figure it out. What do you think? Well, what can we do? Here's my ideas. And to be honest, over the last 9 years, I've gained a lot of experience and a lot of issues that when they came to me, people didn't really know how to handle and didn't know what to do. And because of my background, being a criminal defense lawyer, I didn't come into this and I didn't look at these cases as a creditor rights organization or even a collection agency. And I came in and I'm a litigator. I'm okay. It was, these are the issues I see. What are we going to do with it? And so it wasn't, okay, I want to make sure I collect my money. My goal was to make sure that attorney that's on the other side and causing havoc realizes this is a losing proposition and he finds another line of work and another source of income. And, that's really been my MO and what I've done for, like I said, the last 9 years.
It's incredible. It's a it's something that's very needed from a collection standpoint, right? There's always I'm going to throw up the air quotes when I call them consumer attorneys that are just out to litigate. And I know in the end, the consumer is seeing very little of that to begin with.
Right.
And we're just padding the attorney's pockets. And, their strategies have moved very much online in terms of generating the opportunities for business that they're finding. And they're using all kinds of subpar strategies from what I'm seeing from an SEO standpoint and an online standpoint in order to generate those opportunities to communicate with a consumer and convince them to litigate or to sue the collector versus paying them regardless of whether or not the debt is owed. I find that to be distasteful in general, but hey, that's the business line that they've chosen.
Well, it reminds me a little, you get in trouble criminally, you get a DUI or what, you're going to get 15 letters from 15 lawyers. Hey, I'll represent you. These guys, it's really the guys that are good at it, at figuring out how to use, social media or internet or whatever. There's the same 3, 4, 5 people you see all over the state. And there's 2 or 3 firms down in Miami, but I see them in Alachua County, which is Gainesville, which is north of me, and I'm in Tampa. I see him in Tampa. I see him. There's a guy there's the guy in Tampa. I see him all over the center part of the state. There's a guy in Jacksonville. I see him far south. And so, but most of the people are going to 4 or 5 guys, and it's those 4 or 5 guys who have had success. Their goal, is to be such a nuisance that the plaintiff just wants to settle a case. Let me get out. I can get out for $2,000. I can get out for $3,000, which that's core to how I started. I don't know. There's an expression I like that says bears and bulls make money and pigs get slaughtered. And these guys back in the day, they were settling cases with the debt buyers for cheap money, $1,000, $1,500, or whatever it is, and a dismissal of the debt to the consumer. And then they started asking for $1,500. Then they started asking for $2,000. Then they started asking for $3,000. And I think somebody along the way said, okay, we're spending, this is costing, somebody in underwriting went, yeah, this isn't going to work for us. We need to do something. And that's really how I started, got involved and was first brought in. I was somebody to do something about it.
Yeah, well, at some point when you're being bullied, you push back, right?
Right.
And I think a lot of organizations have started pushing back against the bullies because they knew that they were, and especially as compliance has increased through the years, right? And as the confidence level in the documentation and the underlying supporting documents on any individual account have improved, I think the confidence level in fighting back against those frivolous suits has definitely driven the industry forward.
Yeah, well, totally. And I mean, when I started, I'd say, okay, give me your, I call it original account level documentation, and there's actually some support for that term, but give me all your original, and they would, the debt buyer, let's say the credit card case, all they'd have is the last activity statement and the last statement. And at some point they had the charge-off statement. There's an attorney at Tampa who was using the charge-off statement and getting judges convinced that there was no meeting of the minds as to what was owed because the charge-off statement said 0. And I said, you guys need to get 12 months minimum. You need 12, you need a history. And again, it was me looking at it from the perspective of, a litigator and not a debt collector. And the debt collector's like, I'm good, they're comfortable, but if we're going to go litigate a case, we need to do a little something more because we can go down the litany of issues. When I only have 2 statements, it's an issue. But if I've got 12 months, I can disprove all those issues. The last 3 or 4 trials I've cited to 2, even in front of a bench trial, or I focused in jury when I'm closing argument, the believability of witnesses paragraph, and it's basically the same throughout the country and federal. I think Florida's is based on the federal, which basically says you can believe or disbelieve a witness. In addition, you can use common sense and make reasonable inference. There's two jury instructions. And I go, Judge, you're the trier of fact. You need to listen to what this guy is telling you. And what happens a lot is these guys get trained by the defense attorneys. Okay, listen, you got statements, you made payments, but then all of a sudden you stopped getting payment. You got statements. So, you never saw this final statement. So we're going to say you never saw that final statement. So, we will be good. And they'll never, and they can't prove one of the elements of the cause of action because there was never a rendering. Well, I gotta go to the witness. Let me see if I get this straight. You lived at 407 Main Street in 2012, yep. And you lived there in 2013, and you lived there in 2014, yep. You never moved. And you were just getting statements from Synchrony Bank, yep. And then one day they stopped. Yeah, that's right, never got them. And that was those were the harder ones. Judge, do you really believe that? Let's look at this jury instruction. You really believe that? And so that was the sort of thing that my background sort of brought to the table. I don't think people were really thinking about because it wasn't, they're trying to just do, get out the letter, the demand letters, get that lawsuit filed, get in front of a judge, get the guy into the courtroom and settle the case. Whereas when these attorneys showed up, they really weren't ready for that. They were stuck. And I've been fortunate in that the firms I was with, and now with my step forward, I get the opportunity to take something that's it's a $1,000 case and know that this is going to litigate like it was $100,000. And what I found too, and when people come to me and they said, hey, we're interested in you, this defense, what do you do? I said, listen, you're going to pay me more money today to litigate the case because we're going to turn this case on the head. These guys, these defense attorneys, they come at you thinking if they make you work hard enough, you'll throw your hands up, give them some money and discharge the debt. You go, no. We're going to make them work for it. We're going to make it so that at the end of the day, not only did they not get the debt discharged, they probably got a judgment against their client, and they didn't get a penny. So they did all this work for nothing. And so what's going to happen is, this year you're going to pay me more money, but a year from now, 2 years from now, those guys are going to be begging to get out of these cases as quickly as possible. And you see it. I have been a victim of my own success. I had a client, they gave me 300 cases last year, January, February, March. By November, I had 10 because they all either I won the case, they settled, or but it was got rid of them. And so my pitch to my clients is don't let these guys intimidate you. They throw everything against the wall thinking you'll get scared. We're not going to let that happen. You're going to win this case. And that's what we do. And the biggest shame in all this is, and I've said this to attorneys and their clients, like in a mediation, these attorneys will risk a judgment against their client hoping to get attorney's fees at a later date. And I've literally taken a depot. I've taken the depot of the defendant. The defendant has admitted his debt, admitted he owes the money, admitted he didn't pay it. And I turn and finish it. Turn and say, you want to settle this? No, we're going to go to trial. Okay. You're putting this guy at risk because you're greedy. And I think what's happening too, you're going to see that the defense bar is going to be a little more particular about what they bring lawsuits with. And they're going to be more inclined to figure out how to make money off the case by, getting $500 from the consumer, as opposed to going, don't pay me anything. I'm going to go get the money from them, because they're just not going to get the money from them.
I think you and I are fighting the same battle from different perspectives. A lot of what I spend my time doing is defending the online reputations of the organizations in the space, the debt buyers, the agencies, the law firms, and fighting back against those virtual attacks on a regular basis. And they are funneling money in, and it is a constant struggle and battle. Whereas on the other side, once they have been able to identify some consumers that have a debt with a particular debt collector and have convinced that consumer to move forward with litigating versus paying the debt that they already know they owe, you're on the other side assisting those agencies and law firms and debt buyers with protecting themselves in the courtroom itself, which I think is just kind of two interesting ends of the same spectrum. I think your job's probably a lot harder than mine.
Not about hard. Mine may be funner. I like to win.
It's a constant battle, and I think that's probably the part of it that I enjoy is that constant. It's a constant game of chess, right? It's a game of chess with no end.
Right. Well, you bring up a good point. Made me just think about it. When I started in 2015, the CFPB had issued consent orders against several large consumer, and I don't need to rehash who. So what was happening in 2015 and before is consumers were going into court saying, Judge, I owe the money, but look what these people are, look what they've done to me, and look what they did this, and look at the documents. They don't have documents. So we were back in the day when my first few clients, one of the things I had was a chart of counties and judges who we thought was pro-consumer, who we thought was not. And it was a lot of pro-consumers. But I think since that time, the industry as a whole has really turned itself around. I don't, do you see these
claims? I got
claims?
some insight on that for you.
And it has. So now I go into court. I've had two judges complain about the defense's litigation tactics, the defense attorney's litigation tactics. And so what I found is 9, while there's still pro-consumer judges out there, and I get it, 90% of them are at worst right down the road, or as they should be right down the middle of the road, at best for us, worst maybe. They know this attorney, and they know this attorney's just playing a game, and they're not going to put up with it. And I can think of a judge in West Palm Beach who's just like that, who at this point he's like, Judge, I want to give you 10. I mean, he doesn't even, he knows, because I got the documents, why would I have all these account statements if I didn't know the account, right? And all these accounts, it's not robo-signing fake affidavits. Look, Judge, I got 12 months of statements, his name, his address. He's admitted he's admitted these are his. Why are we here? And it goes. And the same thing with juries. These guys, they've stopped. I kind of beat a few of them up on jury trial. I've never understood why they want jury trials. Maybe back in 2012, 13, when they could really throw a lot of garbage at the debt buyer and the collector.
Before the RMAI certification program,
right.
Before RMAI came out with a certification program that required certain documentation standards to be met in order to purchase accounts by debt buyers.
Right.
And so those debt buyers that were certified had to have these things in place, which clearly was for a reason.
Right. And so, right. So so I've got the documents. I'm comfortable with the documents now. There's some case law in Florida, and you'll find it elsewhere, where I don't even need the original creditor to get the documents into evidence. I don't even need somebody who's been trained in the document. You got the documents, right? You own them. And there's a whole line, we could do a whole story on getting evidence, a whole podcast on getting evidence into evidence. But juries, I've yet to meet a juror who thinks, well, I pay my bills. He doesn't have to pay his. Maybe back in the day when there was a problem and they were having issues and the defense attorney could throw a lot of garbage at the wall, they go, you know what? I'm okay with him not paying his bill. But it doesn't happen now. That was like, show me your collection notes. Who cares? If you've made a mistake, look, and if there's an error, I'm going to say, hey, Bill, we got our June or whoever, we got a problem here. This is going to be an issue for you. It's a real response. Mistakes happen. Sometimes you say, you know what? Yeah, it's a mistake, but it's not a fatal mistake. It's in bona fide error defense. Sometimes it's like, yeah, what are we going to do here? You really, let's get, how quickly can we get this resolved? But it's a real reason. I'm not just doing it to get rid of him. I'm doing it to protect my client.
And I think that a lot of that comes down to kind of the same thing, right? Like the ship is a lot tighter than it was, 20 years ago. And I think now we're dealing with an industry and debt buyers that are far better versed in their documentation. The technology has improved exponentially, the ability to manage vast volumes of documentation. And if you consider how data management has evolved over the last 15, 20 years as well, I think it all plays in quite nicely. Wow, Michael, it sounds like you've got a lot of insights to be sharing with our industry into the future. And I really appreciate you coming on and sharing some of those insights with our audience.
Oh, thank you. Thank you. I love to talk about this stuff. Shockingly, I don't know how it became a passion. Like I said at the beginning, I sort of fell into this role, and it just grew. And I can tell you when I quit, I even got calls from some of the defense bar say, hey, would you be willing to come to this side of the fence? You willing to go to the dark side, or of course they call it the light side, but whatever. And I'm like, no, I just can't see myself doing the work you do. I've taken too much, passion into where I'm at and what I do to just say that doesn't matter. That was all fake. And, I'm here and I've gotten this far because I really like what I do, and I'm really passionate about what I do. And I think that the industry is an important one, and they're reasonable and they're very ethical. I don't know what happened in 2010, and I don't care, and the robo signings and all that stuff. I know what I see now, and I know when I talk to my clients, they're there to make sure it's done right. And if it's not done right, they're there to get it corrected. So very happy.
Well, for those of you that are watching, if you have additional questions you'd like to ask Michael or myself, you can leave those in the comments below, and we'll be responding to those on LinkedIn and YouTube. If you have additional topics that you'd like to see us cover, you can leave those in the comments below as well. And hopefully I'll be able to get Michael to come back at least one more time to help me continue creating great content for a great industry. But until next time, Michael, thank you so much for coming on. I really appreciate your insights.
Thank you. I really appreciate being here. Thank you.
And for those of you watching, we'll see you again soon. Thanks, everybody.